Get ready for the dictation in 3, 2, 1, start. The Article 329 of the Constitution of India specially bars interference by courts in electoral matters, and the legislature was fully aware of the fact that interference in election matters would cause direct injury to the democratic institutions in the country, and as such interference in electoral matters by the courts was constitutionally injuncted. Stop para. The Section 117 of the Act of 1994 is reiteration of Article 243(o) of the Constitution of India, prohibiting interference of the courts in certain matters and in particular questioning the validity of any law relating to delimitation of constituencies, of wards, and allotment of seats, such constituencies made under the Act. Stop para. The judgment passed at the principal seat of this court at Jodhpur in the case of Mushi Khan versus State of Rajasthan and others, under bracket DB Civil Writ Petition number 8157/2014 bracket close, and other connected cases dated 19/12/2014, was put to challenge before the Apex Court by way of filing SLP, and the Apex Court on 26/2/2020 in Asulal and others versus the State of Rajasthan and others, special leave appeal C, permitted the petitioner to withdraw the petition, and question of law involved therein was left open. Stop. Counsel submitted that leaving the question of law open by the Apex Court does not mean that the High Court could revisit the issue, and it has to be interpreted by the Apex Court alone. Stop. Counsel further submitted that the law decided by the division bench of this court in the case of Bhupendra Pratap Singh Rathod versus State of Rajasthan, under bracket DB Civil Writ Petition number 12960/2014 bracket close, and Jai Singh versus State of Rajasthan and others, under bracket DB Civil Writ Petition number 17993/2019 bracket close, continues to be a good law, and until the legal issue is decided by the Apex Court, the judicial proprietary demands that the issues settled by the division bench are to be followed. Stop. This court at the first instance is required to decide the preliminary objection raised by the respondents about maintainability of the writ petitions under Article 226 of the Constitution of India. Stop para. This court finds that the petitioner in the present writ petition have pleaded that validity of any law is not being questioned by them, and as such the bar contained under Article 24A of the Constitution of India will not be attracted in the present facts of the case. Stop. The court finds that counsel for the petitioner have also argued that they are seeking true implementation of the provisions as contained under Section 15 and 16 of the Act of 1994, as well as Rule 7 of the Rules of 1994, and As such, the bar contained under Article 243A of the Constitution of India cannot be made applicable and the writ petitions are maintainable. Stop para. This court further finds that counsel for the petitioners have argued that power of judicial review is the basic feature of the Indian Constitution and the High Court cannot remain a mere spectator against arbitrariness of the state authorities, and the writ jurisdiction of the High Court under Article 226 of the Constitution of India cannot be taken away. Stop para. This court finds that the provisions contained under Article 243 of the Constitution of India have been incorporated vide 73rd Amendment to the Constitution, and after the decision of the Apex Court in the case of Keshwanand Bharti under bracket Supra, the power of judicial review has been held to be a basic feature of the Constitution, and the bar contained under Article 243 of the Constitution of India has to be understood against ordinary courts and not against constitutional courts. Stop. Thank you.